Frequently, we see physicians choosing to pick trusts way more often than will-based estate plan. Both of those documents indicate who's going to get your property when you pass away. So it has clear instructions there on these people get my assets if I'm not around. But trust is better on a lot of different levels that is more appropriate for physicians. So first, trusts have incapacity planning, whereas wills do not. Okay, so what does that mean? It means that if you were to become incapacitated, a trust will talk about who's going to become your successor trustee, who can take over managing your assets in that trust if you are no longer able. And trusts are the best way to avoid court involvement in your affairs with having like a conservatorship where a court is deciding who's going to be acting on your behalf, and then that conservator is going to have to be reporting down to the penny annually on how they spend your assets and have court hearings. And when you have a trusted family member acting as successor trustee, having this immense amount of court oversight can be a waste of money and time for the family. So that's the first thing. Now, some people might say, well, with a will-based plan, you just have a power of attorney, so isn't that enough? And I think there are two different issues with just relying on a power of attorney in the event of incapacity. The first thing is a power of attorney is not as flexible of an instrument as a trust is. And so a trust allows us to have this role called a trustee substitutor. Let's say if you're not able to serve, your wife is serving, but your wife is able to substitute who is acting on her behalf. If she wants to have a child act as trustee with her, she can. If your wife wants to nominate someone else to serve or a bank to serve after her, she can. She has the ability to alter who are the trustees acting on your behalf, even if you're incapacitated for a long period of time. A power of attorney doesn't have that ability. It lists agents in an order, and there's no flexibility in altering that unless you do it yourself. And if you're incapacitated for a long time, that may not be possible. Second of all, trust is the best for incapacity planning for physicians because sometimes powers of attorney can be dated. And institutions will have internal rules that will say, if this power of attorney was signed more than X number of years ago, we won't take it. And so there can be this problem with institutions refusing to honor and accept powers of attorney. And that is not true with trusts. If trusts were signed decades ago, for some reason, they do not have policies that reject trusts and trustees. That's another reason why it's powerful to have a trust in the event you're incapacitated. Another reason why physicians oftentimes choose trusts over wills is because they want to make it easy for their families in the event of their passing. That is something that's really, I think, on top of mind of a lot of our clients. They know that if they were to pass away, it's going to be really hard for their family to pick up the pieces and move on. It's going to be a hard time of their family's chapters in life, and they want to ease the burden as much as they can. And a way that they can do that is by avoiding probate. If you title your assets correctly and you have a trust, you can avoid probate. And so that can mean that your affairs are private. You're not going to be having a court supervising. You're not going to have to publish. You're not going to have to submit a petition to the court that has an inventory of what you owned at death and what you owed. And that petition is public document. So there's a privacy aspect, there's a ease of administration aspect, and also there is the ability to kind of really take the reins right after someone dies with a trust. So the moment someone dies, as soon as we have a death certificate, we can get that successor trustee appointed. Whereas with a probate, when someone passes away, we have to prepare all this paperwork, we submit it to the court, we ask to have a hearing, but that hearing usually doesn't happen for at least 6 weeks thereafter. So oftentimes it's reasonable to expect about 8 weeks after someone dies, there's not really anything that can be done with a probate hearing. Whereas with a trust, that's not the case. You can just take over the reins almost immediately and pay expenses if needed, pay for different things that are needed almost immediately. So that is another reason why I think physicians oftentimes highly prefer getting a trust based plan. If you have questions about estate planning, we are here to help, and we offer free consultations to new clients. Just give us a call at 507-252-8997, and we will sit down and listen to your needs and craft out a plan specific to your situation so that you can take care of your family when the time comes.